I'm Mark Stevens, author of Government Indicted, website markstevens.net. Got a quick video about another dishonest tactic that prosecutors and bureaucrats in general like to use. This is a call of shame, but unfortunately I do not have the audio available for this particular call, but it's still some good stuff. It wasn't very long anyway. Calls of prosecutors tend to be very short. They don't like being questioned. And even though it started out all right, it ended with him hanging up, talking over me, not letting me finish a sentence, and just hanging up on me. But this is dealing with a very common one you've heard me talk about on the show before. It's about flipping the burden of proof, and it's pretty dishonest. Whether it's done by a prosecutor or not, it's pretty damn dishonest. And so let me get into this. He's a prosecutor up in Canada, and this is dealing with a criminal prosecution. So before anyone tries to say, basic principles of logic don't belong in a court, Mark, not true. Anyone who tells you that is just being dishonest. The burden of proof in a criminal prosecution is the same as a basic principle of logic, that the burden lies on the one making the claim. So the prosecution bears the burden beyond a reasonable doubt to prove with evidence every essential element. That's basic common sense. And it does come from the fact that they had to, the system had to appear to be what it said it was, and that was a system of justice. And so it had to be based on basic rational principles. Even though its foundation, it really rests on the foundation of violence and in lies. So, it is a basic principle of logic. I quote here in the article, "The burden of proof, also known as the onus probandi in Latin, is the obligation on somebody presenting a new idea or claim to provide evidence to support its truth, a warrant. Once evidence has been presented, it is up to any opposing side to prove the evidence presented is not adequate. Burdens of proof are key to having logically valid statements. If claims were accepted without warrants, that is without evidence, then every claim would simultaneously be claimed to be true, and you don't have a basis to determine which claim is actually true." So, very important. It's like I wrote in Government Indicted. It's turtles all the way down. So and this is basically a statement of when someone went, well, where's your proof that the Constitution and Code apply to me just because I'm physically in Canada? Well, John Rook said so. Well, where's his proof? Well, some other lawyer said it, and then another lawyer before that, and it's turtles all the way down. So you're talking about opinions, and so it's a long train of a proof by assertion fallacy, that if we get enough people to say it, then it somehow magically becomes true. And that's just not how things work in the real world. When it does happen in the real world, it's dishonest. That's why I say it's a dishonest tactic. So what I recommend what we do when we're using a Socratic method, we're bringing out contradictions. So you have to get agreement and know what the other person's position is. So he readily agrees that he operates under the presumption. Remember, this is a prosecutor, a current crown prosecutor up in Saskatchewan. And I asked him, does your office operate under the presumption that if, we'll say, Max is physically in Canada, then your Constitution and laws apply, and that would give the government jurisdiction? And he said, yes, that's how it works. Okay, great. So I follow up. Remember, this is not just part of jurisdiction, it's an element of the charge. It's a code violation. There is no violation without the code. So to say the applicability of the code is not an essential element, no, you cannot prove a rule was violated unless one, the rule exists, which you can show it does. Two, you have to show it applies in the first place. So I asked in the follow-up question, hey, do you have any evidence? And evidence being facts that have a tendency to prove a proposition and support a claim. He said, I have to think about that. That's a direct quote. I have to think about that. Then there was a long, pregnant pause. And he finished saying, okay, I'm not prepared to answer that right now. So you didn't have the confidence of YouTube commenters to just fire off the answer. Mark, you are an idiot. Evidence is not required. So apparently he should watch some of my videos. Well, not watch the video, but apparently he should look at the comments being made on my video so he knows better how to prosecute these cases. So I wrote down his answer, and I got a little off track. Well, he didn't want to answer directly about a witness with personal knowledge to support that claim. So I brought back, before he was going to get too upset and hang up the phone, I wanted to get back and make sure I understood his position, that he didn't have the evidence, or when we could call him back and he would be prepared to answer the question. So at this point, he, realizing, I think he's in trouble here. He's a prosecutor. He's in a current prosecution. He cannot prove the foundation of his case. So what he does is, oh, that's right, flip the burden of proof. This is really dishonest. It's a logical fallacy, and it's dishonest. If you're in court, object to that. And you ask a question. Objection, isn't the burden of proof on the prosecution? It is. Then either the prosecutor has the evidence or he doesn't. It's not up to me to disprove what hasn't been proven yet. Give me a break, for heaven's sakes. But I figured, hey, since we're not in court, I made my statement. I asked him in the form of a question. I said, well, the burden is on you, right? He tried to get away from that. And then I said, well, look, isn't the fact that you can't prove with any evidence your claim, isn't that sufficient proof? Your own statement, I am not prepared to answer that. Isn't that evidence disproving your claim? Well, he didn't like that. He hung up on me. But think about how dishonest that is. I don't need any evidence to support my claim, but you need evidence to prove it's wrong. Oh, God, no wonder you need a prison system there, buddy, because nobody would listen to someone like that. That's ridiculous. Oh, man. So in court, definitely make your objection. Out of court, just say, excuse me, and bring out through a question the contradiction. Isn't the burden of proof on you? That's what I thought. Then where's your evidence? And before someone says, well, he can make a prima facie. Yeah! But you don't do that with allegations. You do that with evidence. You don't do that with, I'm not prepared to answer that right now. You do it with evidence. And some may say, well, he doesn't have to prove that. He doesn't have to have evidence. Well, if he doesn't have to have evidence, why would I need to have evidence to prove it's wrong? See, we're getting into another logical fallacy here we'll address in just a moment. So the thing is, the rules do require that the prosecution have evidence to support their claim. You don't get to pick and choose, well, these are special claims. This is trite law. Everybody knows that. You got to have evidence. If everybody knows it, then take 5 seconds and show the evidence proving why it's true. Otherwise, it doesn't matter just because everyone else accepts it. Has to be proven beyond a reasonable doubt. It's not just jurisdiction, it's an element of the charge. And you don't use trite law to prove an element of the charge beyond a reasonable doubt, or you're in a rigged system. Oh, yeah, unfair. And then when the judge also treats it, allows him to argue without evidence, and then treats it as irrefutable or irrebuttable, that it's absolutely, and you can't challenge it, that is unfair, and that is a serious due process violation. So yeah, it is extremely dishonest. The other thing that I mentioned, that it brings out another logical fallacy of a double standard. Now, before people say, oh, you can't raise logical fallacies in court, the hell you can't and shouldn't. You damn well shouldn't, because you know why? You don't have to say it's a double standard. All you have to do is try to argue without evidence. Or you could ask the judge, objection, you're allowing the prosecution to argue without evidence? Do I get to do that? No, sir, you need evidence. Bam! There's your double standard. It's not fair. You know how they put above the courts, like in Arizona? Equality under the law? If the prosecution gets to argue without evidence, then the defense should get to argue without evidence. I don't think that's the way it should be. I don't think anybody should argue without evidence. Because arguing without evidence, you're dishonest and you're a crook. And if you fail to see that that's a dishonest double standard, then you either don't understand logic or you're a crook, because you just don't care and you don't want to admit it. So don't be discouraged. If you see something that's unfair, you've got someone flipping the burden of proof, object and call them on it. If you see them using a double standard, object and call them on it. And then try to get away with the same thing. It's like a prosecutor not having to prove he has a client. Great. Call someone out of the out of the peanut gallery. I've done it. It enrages judges because they know that they're being unfair. And when you call somebody out to represent you, they'll start howling and screaming about qualifications. All of a sudden, the rules apply to the defense, but never to the prosecution, because it's a rigged system, it's dishonest, it's unfair, and to turn around and say, well, you shouldn't point that out because, well, we think that those logical principles only apply in a high school debate. Fungal with that. That's not, please. If it's unfair, object and call them out on it. But stick to the questions. Don't make affirmative statements. Hey, that's a double standard. Bring out the contradiction in your objection and in your question. Okay? It's that simple. Doesn't mean it's going to get tossed out, but it certainly goes a long way to getting these tickets thrown out and preserving the issue for appeal if, in fact, you have to do that, which in some cases you do. But that's it in a nutshell. If you disagree with my evidence or the facts that I presented, if you disagree with my analysis that there's a flaw in the logic or I'm just full of crap and you can explain why, you're more than welcome to do so on a live broadcast. You can contact me at markstevens@mail.com, and markstevens.net is the website, and I look forward to your dissent.